Constituent incompetence. Now, legislative incompetence, you are differing. And is it because one is trying to make a change or variation in the constitution, or is it because the other exercise is in respect of a legislation you are making the difference, or there is any other constitutional apart from the words used in Article 368?
Yes, grateful. The reason for my making this distinction is that in the case of a law being passed, as the procedure prescribed in 196 to 200, Article 196 to 200.
Yes.
Even in these articles, your lordship will not find the word act. The bill is passed, goes to the governor or the president and assented. But in Article 123 and 213, which is ordinance making power, there is special mention that once the ordinance is passed, within 6 months, it must be placed before the houses and converted into an act. So therefore, there the position is that the legislative amendment, once it is passed, it itself becomes a statutory provision and act. Here the constitution stands amended in terms of bill.
Bill has to be introduced in the parliament to be passed.
The amendment act is an act by itself. It's another matter that in the publications we find that that is incorporated. And at the foot you will find that that is an amendment act inserted by this amendment act. But that amendment is a separate independent enactment which then inserts itself into the main enactment. Not a matter of great substance, but this is a distinct procedure there. There is no provision which says that the moment the bill is passed, the original act will stand amended in terms of the bill. So this is a very potent expression. Mr. Nariman, Fali Nariman employed this expression for getting the reference. And I am banking on that very expression for a different conclusion. What he wanted to say was that once the bill is passed, then it becomes incorporated. The earlier provision is gone forever. It will not return. That was his logic.
You are using Nariman's Gada for another purpose.
Yes. The Gada is there in 368. But we are swinging it in different directions, one on the right, one on the left.
But on the third situation, of course, is the second was legislative incompetence.
And the third is where the law is
fundamental rights.
breaching the fundamental rights or some other constitutional limitation, like in Article 286.
Now, 13.2 says that any law which is in breach of Part 3 is void. So, how is that voidness distinguished from a law which is void on the ground that, or an act which is void on the ground that it is in breach of the basic structure?
So, on 13, there is some divergence in the judgments of this court. Initially, from case
constitutional amendment.
Only to a law.
Even it's 3.
So, constitutional, this Keshav Madhav Menon, Peshi Kaka, and Sundararamayar. Sundararamayar was dealing with breach of Article 286. So the cases from Keshav Madhav Menon up to Peshi Kaka, they were dealing with Article 13(1), which is existing law, which continues by virtue of Article 372. And since it was a law made before the advent of the Constitution, it will never be void from inception. So it becomes void with effect from the date when the Constitution was made and to the extent of inconsistency. Article 13 in both 13(1) and 13(2) says to the extent of inconsistency, which will always be the case. So the doctrine of eclipse, etc., came into play.
Yes.
Now, in that respect, there is no difference between 13.1 and 13.2. Both say to the
Void.
extent of inconsistency, void. But because of the very nature of 13.1, the laws which are being considered being of the past, therefore, it is said that the law remains on the statute book. It's one, it is good for the past. Second, if the breach is of Article 19, now that's another feature, that these cases are dealing with cases of breach of Article 19, which is limited to citizens. That's a right conferred exclusively on citizens, not on non-citizens. And companies are not citizens, as the law stands. There is some debate on that because of the wide range of activities which the companies today are regulating and operating on. But keeping that aside, the 19 is limited to citizens. So the debate was that even if the law has been declared void on the ground of 19.1F, that was Valsara. And that's how it was Deshikaka emerged to find out what is the effect of the declaration. So it is said that even if, though it is non-existent, ineffective, unenforceable with respect to citizens, because their rights have been affected and found to be and declared to be void. But with regard to non-citizens, it survives and remains on the statute book, therefore. So these observations which the petitioners want to deploy are completely in a different context, where fundamental right under Article 19, which is limited to citizens, is impacted. And consequently, a distinction between citizen and non-citizen surviving to a non-citizen. And this is where Ambika Mill's case said that if in such a situation, the laws covered by 13.1 would survive with non-citizens, it would equally survive with the citizens, with the non-citizens in case of 13.2. Sorry. If the law survives on the statute book with non-citizens, in the case of Article 13.1, the same would be the position with regard to Article 13.2.
It doesn't make a difference.
That is what Justice Matthews says, that even with regard to 13.2, if there is a breach of Article 19, which is limited to citizens, so there can't be a different result. So that is a debate, my lord, which is centering on this citizen, non-citizen difference, which is limited to Article 19. Yesterday, my lord, the Chief Justice asked me about what would be the position if there is a breach of Article 14, 20, 21. Now, they are not limited to citizen. This differentiation and this consequence over which there is a debate would not be there in case of breach of 14 and 19.
There's a breach of 14 or 21.
It would be what ab initio, that the result is same. Because fundamental rights are also imposing an incapacity on the legislature in a different way. My fundamental right is a restriction, a limitation on the competence, unless they justify as a reasonable restriction in the various heads, or otherwise on the various parameters which have been declared by lordships, qua Article 14 or 21. There are certain, none of the fundamental rights are absolute. So there are certain criteria to judge the law. That test has to be passed. And today they don't stand in independent silos. Therefore, each of wherever the impact is, wherever the effect falls, that fundamental right, that test has to be.
Therefore, in other words, according to your submission, a law which is in breach of Articles 14 and 21 would suffer from the same consequence as a constitutional amendment, which is in breach of the constituent or which is in breach of the doctrine of constituent competence.
Yes.
That is, it either vitiates the procedure which is spelled out in 368, or alternately, it violates the basic structure.
So I would bring it at par with legislative incompetence, because we are dealing with the legislative law. The constituent power stands on its own. It's a standalone provision, Article 368, which will be judged on the anvil of 368. What is the effect? But legislative incompetence arises on two aspects. One is that you have to have the subject matter in your field. And the second is that you should be on the right side of the various provisions of the Constitution. What you cannot do under the Constitution, any provision of the Constitution, beyond you. So the resultant is same. The only debate arises under 19 because of citizen, non-citizen, which in my respectful submission was, once the court is declaring a provision under 13(2) as void, then it is up to the court, unless the court says that we are making this declaration and limiting it to the citizens alone, the declaration of voidness will have full play. This aspect has not been considered in Sundara Ramayar. And Mahendra Lal Jaini's case is right.
Have you captured this part of your submissions in your note?
Yes.
Mr. Trivedi?
I have Malakal.
Just also like to read along a
Yes.
little bit.
So when Ambika Mill says, that would be a matter for the court's declaration. That's my humble submission. When the court is declaring the law as void, being in breach of 13(2), it's for the court to declare. For there may be so many laws which may not be applicable to non-citizens, may be applicable only to citizens. Then why should that consequence?
It is for the court to either save
Yes.
all the consequences it never attained the status of a bill which was validly passed,
Yes.
and therefore, once that is effaced, the original provision of Article 331C was never, in that sense, substituted. The substitution never took effect,
Yes.
according to you.
So doctrine of basic structure, it goes to the very first step, introduction of the bill. They don't have any power to introduce a bill which amends, seeks to destroy the basic feature.
But who is to say that
Court will say this.
later?
Later, your lordships have said in Keshwanan that on a case-to-case basis, your lordship will decide.
Point now. Would you like to just show us, as my learned brother, Mr. Rishikesh Roy was asking the note which you would like to just read out that how you have formulated it?
Which volume and which?
Volume 2N, my lord, deals with this part. If I may just draw my lord's attention before reading, my lord, to one more aspect of it, that 368 says that in terms that you may amend by addition, variation, or repeal. Even if these words were not there, the word amend will include all these forms. But they did not leave it for implication, expressly mentioned. Now, this is an additional alternative submission that in this case, we have to look at the nature of Section 4. As my lord the Chief Justice said, that it was a case of expansion, enlargement. So the intent was not to, the intention of the Parliament in introducing 42nd Amendment Bill was not to simpliciter repeal 31's unamended 31C. The intention was to add, to bring in some more directive principles for the entirety of Part 4, in addition to 39B and C. So Section 4 is a substitution by addition. It will not be a case of variation, because variation would mean putting 39B and C in some different way. If the same thing is to be put in a different way, then that would be variation. But if A plus B, then it is to be C plus D and E are also to be brought in. That's a case of addition. So the result of declaration would be that the addition goes. And this aspect, Lord, has been brought out in the case of tobacco, what's international tobacco, Indian tobacco. That is volume 5A, page 3218. 3223,
Way.
volume 5A, page 3218, and the relevant portion is at page 3223. It's a case of repeal of repealing act. The context of a tax on sale of cigarettes.
3233.
3223.
3223.
Para 14 to 17. Yeah, please.
Yes.
The ratio of the two separate but concurring judgments of the appellate bench of the High Court is that the 1954 Act had the effect of completely repealing the 1941 Act in relation to cigarettes. And the repeal of 1954 Act in relation to cigarettes by the 1958 Act did not revive the operation of 1941 Act in regard to cigarettes on the principle that the repeal of repealing Act does not revive the repealed Act. Since the 1941 Act stood completely obliterated from the statute book in relation to cigarettes, no sales tax would be payable in regard thereto, either under the 1954 Act or under the 1941 Act. Upon these premises, it was held that the company as a dealer in cigarettes and smoking mixture is not entitled to any certificate of registration under the Act of 1941, as it is neither a dealer within the meaning of that Act nor liable to pay tax. The general rule of construction is that the repeal of a repealing Act does not revive anything repealed thereby. But the operation of this rule is not absolute. It is subject to the appearance of a different intention in the repealing Act. Again, such intention may be explicit or implicit. The questions, therefore, that arise for determination are whether in relation to cigarettes, the 1941 Act was repealed by the 1954 Act and the latter by the 1958 Act, whether the 1954 Act and the 58 Act were repealing enactments, whether there is anything in the 1954 Act and the 1958 Act indicating a revival of the 1941 Act in relation to cigarettes. It is now well settled that repeal connotes abrogation or obliteration of one statute by another from the statute book as completely as if it had never been passed. When an act is repealed, it must be considered except as to transactions passed and closed as if it had never existed. Repeal is not a matter of mere form, but one of substance, depending upon the intention of the legislature. If the intention indicated expressly or by necessary implication in the subsequent statute was to abrogate or wipe off the former enactment, wholly or in part, then it would be a case of total pro tanto repeal. If the intention was merely to modify the former enactment by engrafting an exception or granting an exemption or by super adding conditions or by restricting, intercepting or suspending its operation, such modification would not amount to a repeal. Broadly speaking, the principal object of repealing is to excise dead matter full of superfluities. So what I rely upon is this, that please look at the intent of the assembly when they were introducing section 4. What was the intention?
So for instance, to take your line of argument further, when they substituted the words, the principles contained in Articles 39B or C, they said all or any principles
Yes.
in part 4. What Parliament was intending really was to do this, according to you. Suppose they had said, instead of 39B and C, they had said 38, 39, 39A, 40, reproduced all the provisions of the directive principles, right? Including 39B and C. And that was invalidated by Minerva Mills. 39B and C would still stand. Because, you know, that had been upheld in Keshwanand. So instead of physically enumerating all the provisions of the directive principles, namely 38 to 38 to 51, what they did was they said all or any of the principles in part 4. So does that make much of a difference? If they had done the former, obviously it couldn't have been argued that, the entirety went, because they would have struck down everything but 39B and C. So the fact that instead of physically enumerating all the articles in the directive principles, Parliament used a catch-all phrase, all or any principle, should really not make any difference according to your submission.
So
because that was the intent. The intent was to expand.
Yes. And that intention cannot be ignored. That's the primary thing, very important aspect.
A substitution, in a sense, also involves some degree of repeal. Because when in exercise of the constituent power or the legislative power, the legislature is substituting a provision, it is also implicitly repealing a provision. Because you are substituting in the sense you are repealing the earlier provision and bringing a new provision in it.
So it's, as I said, Lord, once we bring in the intention, we have to see there are substitutions and substitutions. There can be a substitution by addition, substitution which is intended to vary, substitution which is intended to repeal.
A substitution may be of a completely new provision.
Completely new provision.
You want to completely obliterate an erstwhile provision.
Yes.
And bring in a new provision which doesn't even deal with the same subject matter.
So the amendment bill could have said that such Article 32C is repealed, and then would have said that we are inserting something else in its place. Instead of splitting up this substitution, dehorse the context of Section 4 and saying that it involves two steps, split it up. One is erasure and other is insertion. And therefore it is subsumed. Now this theory of split up and subsuming militates with the context of Section 4. The purpose, the intent of Section 4, quite apart from the fact that in terms under 368, it will mean that it never happened. So even if we treat it that it became part, the only thing which goes out is what was added.
Now, what is the next? What anything else now remains in your submission?
Now, there was one in this context, there was a reference to an earlier exercise where Parliament, Lord, it is said, wanted to reduce, but Rajya Sabha,
they wanted to bring it in conformity with Keshwanand, but the bill never passed the Rajya.
Never passed. So in the first case, when they inserted 32C expanded, so they were emboldened by Keshwanand Bharati that it has upheld 39B and C, so we can now have the whole of it. So completely shut out, avoid the courts completely, no scrutiny.
Then they wanted to bring the amended 31C back to the pre-amended.
But the Rajya Sabha said, no, why reduce the powers which we have gained? But that is all prior to the declaration by the court.
And ultimately, that will not affect.
That is only irrelevant.
The legislature wanted to do. There may be a variety of reasons why a bill lapses. Maybe the Parliament, of course, this was the Rajya Sabha, but in a given case, the term of that legislature, the lower house may come to an end. The government of the day may not have the majority in the Rajya Sabha in the case of the Rajya Sabha, but that shouldn't affect how we construe the provision. We'll have to construe it independently.
They could have a thought also.
Isn't it, Joshi? And
It's another matter that had they accepted that amendment, perhaps it would not have been necessary for the court to go into it, because it's reduced. They would have only just examined nothing, because Keshwanand Bharati has already upheld 30, unamended 30. So there was nothing. So of course they did not want to give up, and your lordships made them give it up. In Minerva Mill, when your lordship struck it down. So what they did not do it, the court did it. Now kindly have just two, three cases only on that point which I am building up. That is the Sundara Ramayar. All these cases have expressly said that if it is incompetent legislatively, it's of no effect. And in fairness, the petitioners did not say that in a case of legislative incompetence, it will still remain on the statute book. An incompetence case, never bring it on the statute book at all. Volume.
Page.
At page 421. So this was a case. So if your lordship accepts my first two submissions which I have made, then Lord, it may not be necessary to go into this debate about 13.1, 13.2, etc. It doesn't arise directly in our case. But since it has been raised and made, the principles have been tried to be lifted up and utilized.
By them.
Yes.
After a provision is struck down by the Constitutional Court, any provision of the Constitution or maybe some act also, that attains finality. Is there automatic change in the act also? Because this is never made. You have seen the Keshwananda also. We have seen your L. Chandra Kumar. There are a lot of, now you don't see those changes in the Constitution. They are bound to do it or not? Or is it automatic?
Revival.
Not revival. Provision is struck down. Whether the Constitution is deemed to be amended to
In
that,
my respective submission, the statute stands corrected as it is. Once your lordship declares.
it has to be.
There-
Shall be deemed to be
I'm not
deleted.
aware of a single act which this court has declared or any high court has declared ultra virus where the legislature has proceeded to pass an act to remove it from the state.
Yes, we have not seen that.
So subject to my lord, correction from my learned.
We have also not seen that. These are still there. in the
Never done, my
Constitution.
lords. And I'm grateful for this question, my lord. The parliament has never passed, the legislatures, no state legislature has ever passed. They abide by the dictum of the court, and that's because of the mandate of the Constitution flowing from Article 136, 141, 142, and more importantly, 144, which specifically says that all civil or authorities will have to
Abide by.
act in aid, very strong word, act in aid of the Supreme Court.
That doesn't create an anomalous situation. Somebody sees now.
So there's no anomaly at all. The Parliament never does it in India. We don't need to go abroad, cross the 7 seas, and find out what America is doing or what UK is doing, what they feel like.
Parliament had not been doing, whether it should be done or not.
And they have also not created any Taj Mahal where all these dead acts can be placed as a mausoleum. So it goes, it's gone.
No, only when an amending act, after the amendment is made and it comes to the statute, then the amending act is repealed.
Amending act.
Amending act is repealed. That is all become dead wood.
That is the kind of.
That exercise the legislature does.
Once they incorporate it,
Yes,
but that's a meaningless. But once the court declares void,
that's
I
a
have
judicial verdict,
it's not
unless
subject
they
to
remove the
correction.
basis of the judgment
You're
and
absolutely right.
pass another validation.
No, but they do it. They do it. That's to remove the clutter.
Yes.
That is only removing the clutter, Malus. That is not a dead wood. Since it has been incorporated, therefore. But the dead wood which is resulting from the declaration of the court, I have not come across, subject to correction, if there is. And that is of no effect. One more aspect.
It gets effaced from the constitution or from the
Yes.
statute.
It's not simply unenforceable. No. There was one other, I'm grateful for the question. There was one other aspect which the petitioners presented, and that was that since after declaration of voidness, it remains on the statutory parchment, and it's not a case of repeal. The court cannot repeal it. Only Parliament can repeal it. And therefore, there can't be two provisions on the statute book side by side. Now, this may sound attractive, but what really is happening is there will never be a case of two provisions on the statute book. One is alive, the other is dead. And in our society, where being and becoming is a process which continuously goes on, people getting born, people dying. So the living and the dead are part of this world. So every living organism, which the Constitution is. So therefore, this is nothing strange, Lord, that there is a provision. I'm assuming the worst case scenario that something is remaining there unenforced. So there is nothing militating. There is no inherent contradiction between a revived, alive provision and a provision which is dead, having been declared by the court of law to be so.
That only.
We have cemeteries, so it can lie there dead. No problem. We have to look at what is operating. Sorry.
There is one more question on that. Now, it is at the option or free will of the publisher only what to publish in the book. Or some provision is struck down.
I'm sorry, Murali.
Any provision is struck down by the Supreme Court, finally,
Yes.
right? One is that 144 says everybody will come in aid. So whether in that context, the parliament or the state or the parliament, in constitution or the central statutes or the state statutes, don't follow that mandate by amending the act, because they are to come in aid, number one. Number two, it's the free will of you see this constitution, you must have a copy of it.
Yes, my friend.
Article 323A, 2D, struck down by this court. Chandra Kumar. 323 3A2D. This is at page 310.
323B.
2D. Judicial review. and-
Exclude the jurisdiction of all courts except the jurisdiction of the Supreme Court under Article 136.
This was struck down in Alchandra Kumar.
Yes.
This book doesn't mention it.
So these are the
No,
publications.
this is what I'm asking. It is at the free will of the publisher only. No, how the layman will come to know? He will not search the law for
The
anything.
publisher should not include what is struck down.
Any note, anything, no, nothing is there. 323B, 3D also same.
The note is below, after the entire provision at page 313, if your lordship.
Like
That's correct.
book.
Layman, but then we'll be out of business.
Mr. Shankaran, but one thing to your credit, if you see a little bit of what's happening in this time of the year, I've noticed that your book of the Constitution, your means the one which is edited by you,
At the end
is
of the.
bandied around quite a bit of late.
Yes.
So you might take credit for it.
At the end of the section. I
The
mean, it's
others
the
also
end-
mentioned it about.
At the end of the provision.
Layman will not read it.
My friend has presented to all of us.
Publication also, nothing is
There's
mentioned.
nothing. Under 144, they should have complied.
Published by the Government of India in 2015.
So these are executive exercise of publications.
This
but
is, the
they
question
should
is that
do.
only. If 144 is there, why don't they come in aid and give effect to the judgment?
Yes, they
It is
should.
giving effect to the
At
judgment.
least they should mention somewhere boldly that it
Why
doesn't
can't they-
survive.
Why can't they make the act only of constitution corrected as declared by this?
They should do it. So, right.
Will it come in the legislation, directing a legislation?
In the universal publication word, in the footnote, they have mentioned,
Yes, in some books it is there, some books it is.
some it doesn't.
End
But
of the-
what they should be doing is that they should eliminate it from there.
Yes,
And in the footnote, they should provide that this was the provision which has been struck down.
it should be based on this.
So that one reads it.
This is the automatic act.
And in order to protect their skin, if they are to be questioned, that so-and-so council had suggested that this is how it should be done.
Kindly have this verse.
At some point of time,
With Article 286.
286.
So they said that the Act 286 doesn't say that a law which contravenes 286 is void.
Yes.
So he says the law was valid as to a part which was enforceable. Then that cloud was lifted, and therefore it became valid in its entirety once the bar under 286
So it
was
was
lifted.
United Motors upheld the provision. Bengal immunity then took a
They
different
distinguished
view.
Pesikaka and Dhakras
All are
on the ground that
discussed.
they dealt with Article 13.
Yes.
Actually, there are three extracts there which are important: 421, 427, 428, and 429.
Absolutely right. That's 421.
just it.
My.
Yeah.
May I
At
just,
421,
may I place it?
yes.
Now, in considering the question as to the effect of unconstitutionality of a statute, it is necessary to remember that unconstitutionality might arise either because the law is in respect of a matter not within the competence of the legislature, or because the matter itself being within its competence, its provisions offend some constitutional restriction. In a federal constitution where legislative powers are distributed between different bodies, the competence of the legislature to enact a particular law must depend upon whether the topic of that legislation has been assigned by the Constitution to that legislature. Thus, a law of the state on an entry in List 1, Schedule 7 of the Constitution would be wholly incompetent and void. But the law may be on a topic within its competence, as for example, an entry in List 2, but it might infringe restrictions imposed by the Constitution on the character of the law to be passed, as for example, limitations enacted in Part 3 of the Constitution. Here also the law to the extent of the repugnancy will be void. Thus, a legislation on a topic not within the competence of the legislature and a legislation within its competence but violation of constitutional limitations have both the same reckoning in court of law. They are both of them unenforceable. But does it follow from this that both the laws are of the same quality and character and stand on the same footing for all purposes? This question has been the subject of consideration in numerous decisions in the American courts, and the preponderance of authority is in favor of the view that while a law on a matter not within the competence of the legislature is a nullity, a law on the topic within its competence but repugnant to the constitutional prohibitions is only unenforceable. This distinction has a material bearing on the present discussion. If a law is on a field not within the domain of legislature, it is absolutely null and void. And a subsequent cession of that field to the legislature will not have the effect of breathing life into what was a stillborn piece of legislation, and a fresh legislation on the subject would be. So even subsequent conferment is unhelpful. But if the law is in respect of a matter assigned to the legislature, but its provisions disregard constitutional prohibitions, though the law would be unenforceable by reason of those prohibitions, then once they are removed, the law will become effective without reenactment. Then leaving the rest, if your lordship has.
Now you can go to 427, actually, the bottom of
Yes,
427.
Peshikaka and all are dealt with colors in page 424.
And on the discussion at 427 after dealing with Peshikaka and
427 bottom.
Yeah, the result.
The result of the authorities may thus be summed up, where an enactment is unconstitutional in part but valid as to the rest, assuming of course that the two portions are severable. It cannot be held to have been wiped out of the statute book, as it admittedly must remain there for the purpose of enforcement of the valid portion thereof. And being on the statute book, even that portion which is unenforceable on the ground that it is unconstitutional will operate proprio vigere when the constitutional bar is removed. Please mark this. It's not a general statement. In this case, what happened was that Parliament had imposed a restriction. Under 286, Parliament specifies, supposing that special goods of importance, 4% will be the tax. Now the state legislature makes some law and had said that as and when the limitation is removed, it will be something different. Now, once the Parliament removes, it starts operating automatically. That was the position here.
Then you can see the bottom of page 428. That will be important because
the fact that it is invalid.
Bottom of 428, the last paragraph. Oh, you are on 428, right?
Yes.
That before you leave the last para, about 10 lines from the continuing para. The result, yes, the fact that, yes.
The fact that it is invalid as to a part has not the effect of obliterating it out of the statute book, because it is valid as to the part and has to remain in the statute book for being enforced as to that part. The result of the enactment of the impugned act is to lift the ban under Article 286(2), and the consequence of it is that the portion of the explanation which relates to sales in which property passes outside Madras, but the goods are delivered inside Madras, and which was unenforceable before, became valid and enforceable. In this view, we do not feel called upon to express any opinion as to whether it would make any difference in the result if the impugned provision was unconstitutional in its entirety. This is very important. So even 286.
And now last para there, 428. That then sums it up.
There is one other aspect of the question to which reference must be made. The decisions in Peshikaka and Bhikaji Dhakras both turn on construction of Article 13, which enacts that law shall be void to the extent they are repugnant to the provisions of Part 3. We are concerned in these petitions not with infringement of any of the provisions of Part 3, but of Article 286(2), and the point for our decision is as to the effect of the infringement of that provision. Article 286(2) does not provide that a law which contravenes it is void, and when regard is to be had to the context of that provision, it is difficult to draw the inference that.
And now you can just see the last sentence of that para, whether we consider the question on broad principle
as to the effect of unconstitutionality of a statute or on the language of Article 286(2), The conclusion is inescapable that Section 22 of the Madras Act and the corresponding provisions in other statutes cannot be held to be null and void and non-est by reason of their being repugnant to 286(2) and the bar under that article having now been removed. So the substance.
The argument was that now that the bar was removed, Parliament has enacted a fresh law. This was not necessary, they said, to enact a fresh law. The bar was removed and therefore they could.
Therefore, it starts operating. But they took caution that if in some case it is entirely, then it doesn't matter really whether the provision calls it void or not. If a constitutional prohibition anywhere residing.
So really speaking, your argument places the violation of the basic structure on the same pedestal as a law which is lacking in legislative competence. So that it is then never, it's null and void.
Null and void.
And it is never deemed to have entered the statute book at all.
Absolute nullity. Now this was again considered in Deep Annexure 22 of volume. This is not in that big compilation. It's in volume 2. Volume 2, N.
Page?
At page 1027.
What is the judgment?
Deep Chand.
Deep Chand.
Yes. All constitution benches.
54, yeah.
At page 1036. And here para 14 and 15, 1036. It is therefore manifest that in the construction of the constitutional provisions dealing with the powers of the legislature, a distinction cannot be made between an affirmative provision and a negative provision. For both are limitations on the power. The Constitution affirmatively confers a power on the legislature to make laws within the ambit of the relevant entries in the list and negatively prohibits it from making laws infringing the fundamental rights. It goes further and makes the legislative power subject to the prohibition under Article 13(2). Apparent wide power is therefore reduced to the extent of the prohibition. If Article 245 and 13(2) define the ambit of the power to legislate, what is the effect of a law made in excess of that power? The American law gives a direct and definite answer to this question, fully in its constitutional limitations under the heading consequence if statute is void. Skip this one. Willis and Willoughby and all are quoted. Section para 18. Then they consider right from Keshav Madhav Menon, all cases. Para 18 at page 1039. We shall now proceed to consider the decisions of the court to ascertain whether the said principles are accepted or departed from. That's the American principles. First is Keshav Madhav Menon is there, and then para 20 is Peshikaka. Sagir Ahmad, and then para 25 if your lordship has. at page 1048. Please come to page 1049 towards the middle. The result. Sentence beginning, the result of the aforesaid discussion may be summarized in the following propositions. One, whether the Constitution, Lordship got this portion? The result of the aforesaid discussion may be summarized in the following propositions. One, whether the Constitution affirmatively confers power on the legislature to make laws subject-wise or negatively prohibits it from infringing any fundamental right. They represent only two aspects of want of legislative power. The Constitution in express terms makes the power of legislature to make laws in regard to entries in the list of 7 schedules subject to the other provisions of the Constitution, thereby circumscribes or reduces the said power by the limitations laid down in Part 3 of the Constitution. It follows from the premises that a law made in derogation or in excess of that power would be ab initio void only, or to the extent of the contravention as the case may be. 4. The doctrine of eclipse can be invoked only in the case of law valid when made, but a shadow is cast on it by supervening constitutional inconsistency or supervening existing statutory inconsistency. When the shadow is removed, the impugned act is freed from all blemish or infirmity. Applying the aforesaid principles to the present case, we hold that the validity of the act could not be tested on the basis of the Constitution, but only on the terms of the relevant articles as they existed prior to the amendment. Kindly have Mahinder Jaini's case, which is volume 5. I'm sorry, it is the same volume at page 157. Para 21 at page 172. We may in this connection also refer to the difference in the language and scope of Article 31 and 13.2. Article 13.1 clearly recognizes the existence of pre-existing laws in force in the territory of India immediately before the commencement of the Constitution, and then lays down that in so far as they are inconsistent with the provisions of Part 3, they shall be void to the extent of such inconsistency. The pre-Constitution laws, which were perfectly valid when they were passed, and the existence of which is recognized in the opening words of Article 13.1, revive the removal of the constituency in question. This effect is doctrine of eclipse, if we may say so with respect, was applied in Bhikaji Narayan case. Article 13.2, on the other hand, begins with an injunction to the state not to make a law which takes away or abridges the rights conferred Part 3. There is thus a constitutional prohibition to the state against making laws taking away or abridging fundamental rights. The legislative power of Parliament and the legislatures of the state under Article 245 is subject to the other provisions of the Constitution, and therefore subject to Article 13.2, which specifically prohibits the state from making any law taking away or abridging the fundamental rights. Therefore, it seems to us that the prohibition contained in Article 32 makes the state as much incompetent to make a law taking away or abridging the fundamental rights as it would be where law is made against the distribution of powers contained in the 7th schedule to the Constitution between Parliament and the legislature of a state. Further, Article 13.2 provides that the law shall be void to the extent of the contravention. Now, contravention in the context takes place only once when the law is made. But the contravention is of the prohibition to make any law which takes away or abridges the fundamental right. There is no question of contravention of Article 13(2) being a continuing matter. Therefore, where there is a question of a post-constitutional law, there is a prohibition against the state from taking away or abridging fundamental rights. And there is a further provision that if the prohibition is contravened, the law shall be void to the extent of the contravention. In view of this clear provision, it must be held that unlike a law covered by 13(1), which was valid when made, the law made in contravention of the prohibition contained in Article 13(2) is a stillborn law, either wholly or partially depending upon the extent of contravention. Such a law is dead from the beginning, and there can be no question of its revival under the doctrine of eclipse. A plain reading, therefore, of the words in Article 13(1) and 13(2) brings out a clear distinction between the two. 13(1) declares such a pre-constitutional law as are inconsistent with fundamental rights. 13(2) consists of two parts. The first part imposes an inhibition on the power of state to make a law, contravening fundamental rights. Second part, which is merely a consequential one, mentions the effect of the breach. Now, what the doctrine of eclipse can revive is the operation of a law which was operative until the Constitution came into force and had since then become inoperative either wholly or partially. It cannot confer power on the state to enact a law in breach of Article 13(2), which would be the effect of the application of the doctrine of eclipse to post-constitutional law. Therefore, in the case of 13(1), which applies to existing law, doctrine of eclipse is applicable as laid down in Bhikaji Narayan. But in case of a law made after the Constitution came into force, it is Article 13(2) which applies, and effect of that is what we have already indicated, and which was indicated by this court as back as Sagir Ahmad. Then they go on to explain law that Sir Keshava Madhavan, etc. And the last the next case was the Sambika Mills, which they rely. But in my note at page 10, I'll mention that later on. I'll complete afterwards.
Mills, volume.
Same volume, annexure 8, page 202.
202.
Para 32. It refers to Sundara Ramaiah, Deepchand, etc., but it's necessary to read it to show how now Ambika Mills is trying to move slightly away from. In Sundara Ramaiah, Justice Venkatrama Iyer said that a law made without legislative competence and law violative of constitutional limitations on legislative power were both unconstitutional and both had the same reckoning in a court of law, and they were both unenforceable. But it did not follow from this that both laws were of the same quality and character and stood on the same footing. Proposition laid down by the learned judge was that if a law is enacted by the legislature on a topic not within its competence, the law was a nullity. But if the law was on topic within its competence, but if violated some constitutional prohibition, the law was only unenforceable and not nullity. In other words, law, if it lacks legislative competence, was absolutely null and void, and a subsequent session of the legislative topic would not revive the law which was stillborn, and the law would have to be reenacted. but a law within the legislative competence but violative of constitutional limitation was unenforceable, but once a limitation was removed, law became effective. The learned judge said that the observations of Justice Mahachand in Peshikakal's case, that quay citizens that part of Section 13B of the Bombay Prohibition Act, which had been declared invalid by this court, had to be regarded as null and void, could not in the context be construed as implying that the impugned law must be regarded as non-est so as to be incapable of taking effect when the bar was removed. He summed up the result of the authorities as follows: where an enactment is unconstitutional in part but valid as to the rest, assuming of course that two portions are severable, it cannot be held to have been wiped out of the statute book. It admittedly must remain there for the purpose of enforcing the valid portion thereof, and being on the statute book, in that portion which is unenforceable on the ground that it is unconstitutional, will operate proprio vigere when the constitutional bar is removed. In Deepchand, it was held that a post-constitutional law is void from its inception, but that pre-constitutional law, having been validly enacted, would continue in force so far as non-citizens are concerned after the Constitution came into force. The court further said that there is no distinction in the meaning of the word void in Article 13.1 and 13.2, and that it connoted the same concept, but since from its inception, the post-constitutional law is void, the law cannot be resuscitated without reenactment. Justice Subbarao, who wrote the majority judgment, said after citing the observations of Justice Das, Acting Chief Justice, in Keshav Madhav Menon, the second part of the observation directly applies only to a case covered by 13.1. For the learned judges say that the laws exist for the purpose of pre-constitution rights and liabilities. They remain operative even after constitution as against non-citizens. The said observation could not obviously apply to post-constitutional laws. Even so, it is said that by parity of reasoning, the post-constitutional laws are also void to the extent of repugnancy, and therefore the law in respect of non-citizens will be on the statute book, and by the application of doctrine of eclipse, the same result would flow in its case also. There is some plausibility in this argument, but it ignores one vital principle: the existence of or the non-existence of legislative power or competency at the time when the law is made governs the situation. If Justice Das dissented, he was of the view that post-constitutional law may infringe either a fundamental right conferred on citizens or a fundamental right conferred on any person, citizen, non-citizen, and that in the first case, the law will not stand in the way of exercise by the citizens of that fundamental right, and therefore will not have any operation in the right of citizens, but it will be quite effective as regards non-citizens. When they discuss Jaini's case, kindly come to para 36. If the meaning of the word void in Article 13.1 is same as its meaning in 13.2, it is difficult to understand why a pre-constitutional law which takes away or abridges the rights under Article 19 should remain operative even after the Constitution came into force as regards non-citizens, and a post-constitutional law which takes away or abridges them should not be operative as respects non-citizens. The fact that pre-constitutional law was valid,
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर, और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।